morning. Please be seated. Before we begin, I'd like to welcome the new employees at the Administrative Office of the Court. Here with Jane Van Camp, the Human Resources Director. Welcome. Thank you for your public service, and thank you for joining us this morning for arguments. The first matter is Brett Durant versus State Farm Mutual Automobile Insurance Company. We will hear first from Tyler Firkins for 14 minutes, and then Frank Falzetta for 20 minutes. And either Mr. Firkins or Mr. Nyheim will do the rebuttal. Mr. Firkins.
Good morning. May it please the court, my name is Tyler Firkins, and I represent a class of individuals who has sued State Farm for violating a WAC regulation in this case. The PIP insurance regulation provides that there are only 4 reasons for which an insurer may deny, limit, or terminate PIP coverage. If treatment is not reasonable, if treatment is not necessary, if it is not related to the car crash, and if it was not incurred within 3 years. The regulation unequivocally declares that these are the only grounds for denial, limitation, or termination of PIP benefits. Yet since 1997, State Farm has used a 5th ground, or a 5th reason for terminating benefits. They say that it must also be essential to achieving maximum medical improvement. This clearly violates the law, and State Farm has filed more than a dozen briefs in state and federal court and has never explained the meaning of the language, "These are the only grounds for denial, limitation, or termination of PIP benefits." And they have never explained why their policy provision does not violate that straightforward explanation of the insurance regulation. There is an additional reason why, beyond the straightforward reading of the WAC regulation, that State Farm's policy violates the insurance regulation and the statute. And that is where, as this court has stated in countless cases, including Britain versus Safeco, where the legislature has mandated a certain amount and kind of coverage, any insurance provision that reduces the level of coverage is unlawful. State Farm has never disputed that there are entire categories of medical coverage that the MMI standard excludes that is more restrictive than is the statute. And for that reason alone.
Oh, I'm sorry. I wanted to ask you a question about their position. You say they've never explained the meaning of this provision. And my understanding from their briefing is that they say it's definitional of the terms that already do exist in the code and under the statutes. And I guess clearly you don't agree with that, but I wonder if there's any other place that reasonable and necessary medical expenses is defined, because obviously if State Farm is defining those terms, is that definition at odds with some other existing definition?
Well, it's at odds with a couple definitions, but first and foremost, the statute, it's at odds with the statute itself, the PIP statute, which states that all reasonable and necessary medical expenses are to be covered. And that broad explanation of what are reasonable and necessary is much broader than what State Farm has limited.
Well, I don't know why. Is it the word all? I guess I don't understand if there's no definition. Well, is all a definition?
All is not a definition. However, it does modify the words reasonable and necessary to include all reasonable and necessary. So the question then becomes whether State Farm's definition under Britain and countless other cases is more restrictive. So they cite the case of Daly, which is instructive. In Daly, the PIP policy, or the UIM policy, used the word bodily injury. And the insurance provision in that particular case was identical. It's also said bodily injury or state of disease, or words to that effect. And the court there said that under those circumstances where the words are identical, it is not more restrictive. But here the words are clearly not identical, and in fact there are a significant number of additional words. If you read the plain language of their insurance provision, for a medical expense, it must be both necessary and essential to achieving maximum medical improvement. They have never explained to this court or any other court the word "and." They ignore it in every context and say that the policy defines necessary as essential to achieving maximum medical improvement.
Let me ask a question about the words reasonable and necessary.
Okay.
Reasonable and necessary for what purpose? And in context, what I'm asking is it reasonable and necessary for medical treatment? And does medical treatment include pain and suffering, or palliative care, as it's been called in other contexts? What is the thing that it has to be reasonable and necessary for?
And that's exactly right. The legislature did not define reasonable for what purpose, and State Farm restricts it to one of the most restrictive readings of what would be necessary possible.
So what do you define it as? If the legislature didn't, and State Farm, as you say, has a narrow definition, what's your more ample definition?
Well, we've proposed a number of definitions. One is straight from the dictionary, which talks about the definition of necessary. The other is from Tabor's Cyclopedic Medical Dictionary, which talks about whether the treatment is within the standard of care for the type of treatment provider that's involved. In other words, if that treatment provider is acting within the standard of care for providing that sort of treatment, it's necessary. And they're prescribing it for the individual patient, and it's related to the car crash, then it's necessary. What State Farm does is they eliminate entire categories of potential treatment. As the pain physician said in their brief,
That might make it reasonable, but what makes it necessary, and how do we determine what it means for it to be both reasonable and necessary?
well, I think reasonable, and it's important to understand, this court has defined what reasonable is, and we've cited the cases that talk about that in terms of the WIPIs. So the WIPIs say what is reasonable. It deals with the cost of the treatment. So is the treatment appropriately the appropriate amount of price, or is it reasonable within the community in terms of price? And State Farm's policy is consistent with that because it defines reasonable as the lowest in cost, and then they give various categories. Necessary, then, is something different than reasonable. It is, and you're right, the unanswered question is reasonable for what purpose? And when the legislature says all reasonable and necessary treatments, then to restrict it to something less than all reasonable and necessary treatments would be a more restrictive policy than what the legislature has mandated in terms of.
So you've told us what you think reasonable is. Now, if you'd go on to what you think necessary is.
Necessary is that which the doctor prescribes that is related to the car crash. And we've provided a proposed definition. We're not sure that it's necessary for this court to actually define the term necessary, because necessary is all those reasonable and necessary treatments that a doctor prescribes and is related to the car crash. And what State Farm can't do is restrict that definition by saying it's less than what is necessary. State Farm uses multiple words in its definition, and those words are more restrictive than necessary. As an example, essential. Essential, if you look up the definition of essential in the dictionary, the meaning is absolutely necessary. So that word alone is more restrictive than the word necessary. But on top of that, they add on that it must be curative in nature in addition to being essential. So it has to be essential for the purpose of curing the condition. And our laws have always looked at accident victims, innocent victims of car crashes, and the purpose of PIP and UIM coverage is to get those people back to where they belong. It is to take care of those people. In the case of PIP coverage, what we had was, before they passed the statute, you had people waiting sometimes 3 years and being negatively affected by an inability to obtain treatment for their injuries that they sustained in the car crash. And so the legislature mandated that insurers offer PIP coverage, so when those people are injured, they have an immediate ability to access care, and they access all reasonable and necessary care, which includes care that would deal with chronic pain issues. And as the pain physician said, the cost of pain on society is enormous, and the legislature intended through its policy to reduce and ameliorate that problem.
Well, can I ask you this? I mean, you wouldn't deny, would you, that reasonable and necessary has, over the course of case law, as well as, I guess, the insurance commissioner's interpretation, it doesn't require State Farm to just defer without questioning to what the physician prescribes, right? I mean, a week on a sunny beach in Hawaii would be good for you. They don't have to just say, okay, I guess the physician said that was reasonable and necessary.
That's correct. I mean,
so given that, so it's not just a, well, the physician has prescribed it and it's within the cost range that is normal in the industry for that prescription. So we're already moving into a more qualitative assessment, aren't we, of what's reasonable and necessary?
Well, what has happened through years of litigation is reasonable and necessary has been looked at as a limitation on the ability of people to access treatment to some extent. And the point that we make in our brief is that that limitation should be extremely narrow, because in the context of tort liability, saying that an innocent victim of a car crash, that an insurance company can interfere with the decisions that are made between a patient and their medical provider by simply saying, we decide something different, is inappropriate.
But this, of course, this is PIP. We're talking first party here.
Right.
We're talking that it steps in even to supersede your health insurer. So I'm not sure the tort liability innocent victim is the guiding principle, but maybe I'm misunderstanding your argument there.
Well, okay, so the purpose of the PIP statute is to step in for victims of car crashes so that they don't have to wait 3 years to resolve their claim. And that was the original purpose of the statute. And in every mandatory statute, whether it's UIM or PIP, inherent in that statute is the public policy of mandating that coverage, requiring that coverage to be available to those individuals. And that's what State Farm is taking away, is the mandatory coverage that the legislature has said when they said all reasonable and necessary expenses. And further, when the insurance commissioner has interpreted that statute, which is unchallenged by State Farm, to say that these are the only reasons that you can deny, limit, or terminate coverage are these 4 reasons. And instead they use a 5th reason.
What do you make of the insurance? You say this policy language has been in State Farm's policies since 1997?
It's been in their, well, it was in their medical pay. If you look at the history of this, in 1992, they asked the insurance commissioner to approve new language. At the time, that had to do with their medical pay provision. And at about that time, the PIP statute was coming into effect. It's unclear exactly whether the policy itself was modified to include PIP coverage or whether it just dealt with med pay. But at any rate, the regulation came into effect in 1997, some 3 years after the initial approval of State Farm's policy.
So it's your position that this has neither been approved nor disapproved? It's just not been addressed by the insurance commissioner?
I say specifically that it has been specifically disapproved by the insurance commissioner's office. In July of 2015, they sent State Farm a letter saying, we are disapproving this language, which is absolutely consistent with RCW 4818.110, which allows the insurance commissioner and mandates that they not only approve policies, but when they determine that they're unlawful, that they disapprove policies, which is exactly what they did in this particular case. They told State Farm to stop writing this policy, to amend its forms, to notify its insured, and State Farm has never done that. And that is the last interpretation of the insurance commissioner until the insurance commissioner filed its amicus brief. The other thing I want to point out about that, Justice, is that State Farm cites Dot Foods versus Department of Revenue for the concept. Their argument is that when the insurance commissioner approves a form with thousands of pages to it, that they're approving the specific language in that form. That's not true. If you look at the Dot case, what happened in that case is the insurance or the commissioner in that case approved or created a WAC interpretation of a statute. 20 years later, they changed the WAC to defeat an exemption, a tax exemption for an individual. The alteration in that WAC regulation is their interpretation. The WAC regulation in this case has never changed. From 1997, from its passage until today, when the insurance commissioner filed its amicus brief and agreed with the plaintiff class in this case, that regulation has never changed. The interpretation of the OIC has been the same, that there are only 4 reasons that an insurance carrier can deny, limit, or terminate coverage. And those do not specifically include essential to achieving maximum medical improvement.
Counsel, you're into your rebuttal, but you're welcome to continue.
Thank you. I'll reserve the rest of my time.
Thank you.
Good morning. Thank you, Your Honors. May it please the Court, my name is Frank Falzetta, and I represent the defendant and respondent in this case, State Farm. The District Court certified 2 questions to this Court, the first of which asks, does an insurer violate subsection 1 of WAC 284-3395 if it denies, limits, or terminates an insured's medical or hospital benefits claim under PIP based upon a finding of MMI? State Farm urges the Court to answer that question, no, at least as to State Farm, because the WAC does not define the term necessary. But State Farm's policy form does, and it does so in terms of MMI. Now, State Farm never wanted to define the term necessary in its policy form. It was compelled to do so by the insurance commissioner of this state. When State Farm submitted its 1992 form revision for its auto policy and some amendatory endorsements, they simply had, in their MedPay coverage, the same words that you see in the WAC and in the RCW, 4822-005. It said, we will pay for reasonable and necessary medical expenses. The commissioner said, we're not approving your form, we're going to hold it, unless and until you define both reasonable and necessary in a way that the average consumer will understand. We came back and said, well, we don't need to do that. It's going to be subject to a claim-by-claim process. And the commissioner again said, no, we're not going to approve your form. Submit it again. Then, intervening in that whole process, that was going on during 1992 and 1993. In 1993, the legislature adopted HB 1233, which is the PIP statute. That included 4822-005, which is the definition of medical and hospital expenses under PIP. And that section says you pay for medical and hospital expenses that are reasonable, necessary, related to the accident, and within 3 years of the accident. We all agree on that. But that was April of 1993 when they did that. Now, it wasn't effective until a year later, but everyone knew it, including the commissioner. And a month after that, Your Honors, a month after that, State Farm came back to the regulator, again on the same policy form, trying to get the MedPay coverage approved, and said, now that there's HB 1233, the PIP statute, and it includes reasonable and necessary, we're just going to defer to that statute, and it'll be that statute as ultimately interpreted by the courts. And you know what the insurance commissioner said? Not good enough. You still have to define the term. So we did so. And we did so, finally, in January of 1994, and it's in the record, and we did it. It's docket 7-7, page 41. And we said, all right, here's our definition. We defined reasonable expenses, consistent with the usual fees charged by a majority of the providers in the geographic area. And then we defined necessary as only if the services are rendered by a licensed medical provider within the scope of their practice, and, notice the word conjunctive, and are essential in achieving maximum medical improvement for the bodily injury sustained in the accident. That was borrowed directly from the workers' compensation statutes in this state.
Counsel, let me ask you,
a question. I thought I had the history of what happened in this case in my mind, but I was a little surprised, maybe I didn't have it all in my mind, when plaintiff's counsel said that in 2015, the insurance commissioner specifically disapproved of this language in the policy.
That's incorrect, Your Honor. What happened was a forms manager at the commissioner's office sent a letter, as he had to American Family apparently a few years before, which State Farm does not know about, sent a letter saying, oh, I've gotten notice that you have a definition of reasonable and necessary that isn't consistent with WAC 284-3395. Please stop using it. And oh, by the way, I'm going to refer you for a market conduct exam. That was Alan Houdina's letter. Okay, that came to us. And
that's right. So that was the employee's letter,
correct.
Not the...
No cease and desist. No form disapproval. There's an express statute in Washington.
And your argument is that it's not approved by it's not the insurance commissioner's letter.
It's an employee of the insurance commissioner, Your Honor, but there is a procedure if the commissioner wants to disapprove a form. It's regulated by statute, and it's necessary to give the carrier an opportunity to bring an administrative action based upon form disapproval where we can challenge it. We have notice, we have due process, we have an opportunity to be heard by an LJ. None of that happened here. We got a letter from a forms manager, not a cease and desist order. They know how to issue those. There are many of them. We didn't get that. We got a letter prompted by our litigation adversary. Mr. Firkins and Mr. Nauheim contacted Mr. Houdina and told him we're litigating, they're doing this, you should do something about it. So we were in the midst of litigation when this happened. And a month after we got that letter, Mr. Houdina also referred us to the market conduct group at the insurance commissioner's office, and they opened a market conduct continuum action, and this is all in the record.
But bottom line for us at this point, the question is not really whether you did everything you did in good faith, and we're trying to comply.
Yes.
But whether the WAC, which was duly adopted, was complied with or was violated by the policy, regardless of your good faith or bad faith.
Yes, and I agree with that. But I think it's important to note there has been no disapproval. In fact, the Attorney General, communicating with us as State Farm's lawyers, told us after the internal legal opinion came from the insurance commissioner that agreed with us that our definition of necessary didn't violate the WAC, we were told by the Attorney General's office, no final action's been taken. It's still under review. When there's a final action, you'll know about it, and you'll be an aggrieved party, and you can do what you need to do. That has never happened to this day.
I want to make sure I understand then the way it operates. So if someone is injured and they're, as a result, they have a chronic condition that's never going to get better, but that causes pain, and if they have treatment that makes the pain go away but doesn't improve medically their long-term condition, that would not be covered.
Correct. Palliative care can be approved under MMI until you achieve that plateau MMI status. Then care thereafter under our definition and under the definition of workers' comp and maritime law would cease. The reason? Because it's a first-party, no-fault benefit that's designed to give limited benefits to allow people to recover quickly from an auto injury, but not forever.
Well, isn't 3 years the not forever? I mean, that's your cutoff, right? You can absolutely deny everything if it's not within 3 years of the accident.
That's an absolute cutoff.
Well, why isn't that? It seems to me the difference between L&I or even Jones Act stuff is they get pensioned out, right? Once you've reached maximum medical improvement, that's not the end of the road. It converts. I mean, there's a process, but here it's just a cutoff after 3 years, isn't it?
Right. You get a disability benefit. You get a permanent disability
rating. You get a
rating
permanent disability rating.
But you don't get
You don't necessarily.
treatment.
I said pension, but you get a permanent rating. But here, it seems that if the concern is, gee, this could go on forever, that's just categorically not true because you can cut off everything after 3 years.
That's correct. So the legislature already put a cost containment vehicle on it, but that doesn't say anything about the term necessary, and that's the important point. The legislature didn't define necessary, didn't add the words that Mr. Firkins is trying to add that suggest that our MMI language violates it. And it's very important contextually to understand that, again, we were forced to define it the way we did, and we offered it, and it was accepted by the insurance commissioner as an understandable definition of necessary that a lame person could understand. So,
and you're saying that was done. So I want to understand.
Yeah.
So Dot Foods was a situation in which the Department of Revenue initially had a WAC interpreting a statute in one way,
Correct.
and then subsequently promulgated rule and comment, a WAC, interpreting the statute a completely different way. And so it was a discussion about deference. What do we have here that's comparable to that would suggest we wouldn't defer to OIC's interpretation of this law?
We don't have a prior order or WAC or an interpretive ruling from the body. We only have the WAC itself. But I was going through the timing of how that happened. So the WAC, so we finally get final approval, and our MedPay and PIP coverages go into effect July of 1994, both of them. The commissioner approves that a necessary definition in both our PIP, a mandatory endorsement, and our MedPay, a mandatory endorsement. That's 1994. The WAC comes about in 1997, but all it does is echo the same terms from 4822.005 of the RCW, reasonable, necessary, related to the accident within 3 years. That's July of 1997. So it doesn't really change the RCW that was in place when the commissioner agreed with our definition of necessary and put it in force. Then 3 years thereafter, the commissioner again approves our form with the very same necessary definition in terms of MMI that it had in 1994. So in 2000, they approve our form, and you can see the side-by-side comparison that Mr. Firkins put in the record in his brief in response to the OIC, a little side-by-side that shows the 2000 form and the 2006 form. The exact same necessary language is in there. So again, 3 years post-WAC, they're approving the same language again, and then they do it again in 2006. In 2006, our policy form changes a bit, but only structurally. The same definition of necessary is in there. It's simply rolled under a broader definition of reasonable medical expenses. But it's still there. And if you look at the side-by-side, it's the same and MMI and the same and MMI in both forms.
Mr. Falzetta,
Yes.
this is interesting, but I want to follow up on Justice Gonzalez's question. So about pain and continued chronic pain that you really determine is just permanent. You can't surpass that. What if that pain is such that the claimant really can't work because of the pain? Would that still be excluded as a covered item under your PIP coverage?
I don't think so, Your Honor, because that's necessary to achieve MMI. I mean,
well,
right.
Let's suppose it's not necessary. Let's suppose that you're going to have to live with the pain, but it means that the person can't work. So you're saying that a State Farm would or would not pay that?
Well, if they have attained MMI, and again, we usually ask the treating physician if they've obtained MMI. They're permanent, they're stationary, they're not going to get any better, not really going to get any worse. But they may have residual pain. But if they've achieved MMI, and the treater tells us that in response to the letter that we send, and it's post-MMI pain medication, for example, probably not covered. But there's discretion at State Farm to provide them any care after an MMI determination. And if they tell us they simply can't get up and go to work without the pain medication, I don't know that that would be excluded by MMI at all, because it's required.
Where do you get that conclusion? Just from the words maximum medical improvement?
Maximum medical improvement.
It
right.
seems, though, that your point is that once you achieve maximum medical improvement, even if you can't work because of pain, chronic pain that's permanent, you would still deny. But now you're telling me, no, you wouldn't deny because you'd have discretion.
I guess it might be a timing issue. You say can't go to work. I mean, you're going to come to MMI at some point. And again, a lot of this is soft tissue injury, chiropractic. Remember, this is a $10,000 benefit for most people. It's not going to pay for massive surgeries or a lot of things. These are soft tissue injuries, $10,000 up to $35,000 in benefit if they request it.
Can a person buy more PIP?
Yes,
than the minimum?
if you request it as an insured, you can get up to $35,000. It's mandatorily required that the insurance company give you up to $35,000, but the mandatory level is simply $10,000. That doesn't cover much. In Mr. Durant's case, we paid over $20,000 in PIP benefits, including over $9,000 for 40 massages over 9 months for a soft tissue back sprain. That's hardly being stingy with the benefit. And we learned later that most of those massages weren't even approved by Dr. Rasmussen, the chiropractor, but we nonetheless had been paying them. And we only did pay for 4 massages that occurred after Dr. Rasmussen told us he's permanent and stationary, he's MMI, and we didn't pay for 4 massages totaling $920. That's what prompted this lawsuit.
So you wouldn't pay?
We didn't pay for the massage. And because there was no indication that that was necessary to achieve MMI, and his doctor told us otherwise.
And
so Your Honor, there is a cutoff.
If you didn't have an MMI provision in your policy, would treatments for chronic pain continue even after a person achieved maximum medical
Maybe not,
improvement?
because remember, we wanted to not have a definition. We wanted to say reasonable and necessary, and the WAC itself in subsection 2 says we can challenge reasonable or necessary with an IME. This idea that the treater...
But you're changing the terms here. You're changing from reasonable and necessary versus MMI. And we're trying to find the line where that occurs, or at least I'm trying to find the line where that occurs. And I keep getting from you, we might pay in discretion, but then you say, but once you've reached MMI, we won't pay more.
Typically, we wouldn't pay post-MMI for further additional treatment because you've achieved that plateau.
And there would be a different result if you didn't have the MMI.
No, that's what I was explaining. No, not necessarily, because necessary is subject to review by an IME that we can retain to look at both reasonableness and necessity and decide whether it is or it is not. That's exactly what the WAC subsection 2 allows. The WAC is actually all about use of an IME, and we can challenge that. So that same treatment under the necessary standard, we might consult with an IME who says, no, it's not necessary because it's not really curing or rehabilitative or anything else, and then we'd be in the midst of a claim dispute. And that's where we were until the insurance commissioner made us do what we did here, Your Honors. We didn't do it to try to avoid paying PIP benefits. We wanted to just say reasonable and necessary, and then we wanted to just use the IME procedure in the WAC, but the insurance commissioner wouldn't let us do that. So now we're stuck here with a class action lawsuit over a definition that the commissioner mandated and approved repeatedly before and after the WAC, and now we're told that it's a 5th ground. Clearly not a 5th ground. If the commissioner said define necessary, and we gave them the definition in terms of MMI, and they said okay, they're approving a definition of necessary. So that's my point. If we were back to where it was just reasonable and necessary, we could still challenge it, and that same treatment might still be found to be unnecessary, but through an IME process. That's the way this works. And again, this doesn't come up that often because it's a limited benefit. It's $10,000. It's a no-fault first-party benefit that's designed to give people immediate cash for immediate costs of the auto accident. That's all. And $10,000 medical these days doesn't go very far. And so our definition really isn't inconsistent with that. And that's exactly the motivating force behind MMI in the workers' comp statute and maximum medical cure in maritime. It's get them on their feet, give them this limited no-fault benefit, get them on their feet, contain costs, though, in the meantime, and cost containment is already in the RCW and the WAC in terms of 3 years, in terms of related to the accident, in terms of reasonable and necessary. If the commissioner, if the legislature wanted you to be able to have to cover all expenses, they wouldn't have put all before reasonable and necessary. They would have said all medical expenses. And it would have been a, go ahead, use up your $10,000 limit on whatever you want, let the treater decide. They didn't do that. Not only did they add reasonable and necessary, but then the commissioner adopted the WAC that says, oh, and you insurance carrier, you can challenge reasonable and necessary with an IME. You don't have to listen to what the treater says. You can dispute that. That's just completely inconsistent with what they're saying, completely, and puts us in a very difficult position now, where we're being challenged as violating the WAC, an unfair practice, by doing what the insurance commissioner told us to do. There is some fundamental fairness issue here about all of this. And it'd be one thing if they came to us, the commissioner, and said, we're disapproving your form, here's the cease and desist, you're an aggrieved party, you can appeal or not, and we'll have you issue a new form prospectively. That's one thing. But that's not what's happening here. The commissioner didn't say anything to us other than the forms manager sending us the letter, and to this date did nothing until we got the amicus brief.
Well, counsel, it seems to me like these arguments go to maybe estoppel or some other theory, but we've been asked to decide whether or not this what's being described by your opposing counsel as an additional factor is permitted under the state law and the WACs that implement. So, I mean, you may have great arguments on estoppel or some other good faith if there's a challenge that you were acting in bad faith. But really, my question is then if the real issue before us is whether this is additional language that's different from the standards that are set by the legislature. So my question has to do with essential. So essential in and of itself seems to me to be quite different than reasonable and necessary, because essential sounds like it goes a step farther.
It doesn't, and let me go through your canons of construction that this court has articulated over and over again. First, you try to look at the plain meaning, and that is you look at the words, you look at dictionary definitions, you look at other aspects of the act. Dictionary definition here supports us, and I know I don't have much time. It's absolutely needed. Merriam-Webster, essential, required to be done. Oxford Dictionary is the same, and unlike the 1968 version of the Black Dictionary that was cited by an amicus, the current Black's Dictionary, the same. Necessary is synonymous with essential. So our term essential is no different than necessary in every current dictionary that you look at. Now, then you go through your canons of construction. Okay, so is our definition of MMI, does it conflict with necessary? No, because the legislature didn't define it. So you'd have to add words to it to say that our MMI definition conflicts with it. And then you go on under Kyrkos if it applies, and we don't think Kyrkos applies because this isn't a UIM exclusion, excuse me. But even if it did, then you'd say, are we violating the policy underlying PIP? No, because the PIP policy is first party, no fault, limited coverage, and on top of it, the kicker, the commissioner made us define it this way. And that's not just an equity argument, Your Honor. That's the commissioner saying, yes, that's a proper definition of necessary when they knew about the PIP statute. They knew about RCW 482205, and they said, yep, that's okay. In fact, they quoted RCW 442805 in the letter approving our form.
I understand all about the approval.
And I know I'm over time. I apologize. I get a little passionate about this.
The approval is something that's separate from how we interpret this statute. Whether you got approved and the commissioner was wrong, I mean, obviously we give deference to the commissioner's point of view on how this should be interpreted, but at the end of the day, we have to decide it. So if essential is the same as necessary, then is maximum medical improvement the same as reasonable?
Well, no, because
necessary.
Necessary. MMI is
medical expenses that are incurred within 3 years of the accident that are related to.
Yeah, I don't think reasonable comes into question in this case. It's not about reasonable because I agree that that's about cost, the amount charged. And our form has a different series of definitions of the lowest of these costs. We're really talking about necessary, and that's why I'm arguing MMI is not inconsistent with that definition because it's not further defined by the legislature. They omitted words, and then you should say that that's intentional on their part. And it is consistent in the eyes of the commissioner until the amicus brief because they forced us to do it and they approved our definition. And with that, I thank you, Your Honor, for listening to me. I appreciate your time.
Thank you, Counsel.
Mr. Firkins, you have just under 4.5 minutes.
Thank you. Let me start where he finished and point out that their policy's very clear language says that medical expenses must both be incurred for necessary hospital and so on benefits and essential to achieving maximum medical improvement. And it's the and that creates the additional factor that violates the regulation. So, Justice Mattson, to get back to the point that you were making, the certified question is, does the use of an additional element in this case and essential to achieving maximum medical improvement, does that violate the regulation? And the answer is, if it's different than one of the 4 reasons, because the regulation is clear and unequivocal, these are the only 4 reasons.
Wouldn't that suggest I find these questions 1 and 2 are asking kind of the same thing. So shouldn't we answer the first question first, or the second question first? Because if MMI is synonymous with reasonable and necessary, then it's just inartful, but it's not an addition.
Well, but understand that their policy, they keep saying that they define necessary, and they don't. That's not true. they have two elements in their policy: incurred for necessary and essential to achieving maximum medical improvement. So their argument fails on its face because they have the word necessary as part of the definition. So it has to be two things. And you can see that by looking at their coverage letter, where it lists 5 things that an insured must comply with. It must be reasonable, it must be necessary, it must be related, and it must be within 3 years, and it must be essential to achieving maximum medical improvement. And Justice Madsen, you brought up a terrific point, which is essential is more restrictive. It's absolutely necessary, but it doesn't stop. If they just said essential and necessary are the same in our policies, then maybe they would have a better argument. But that's not where they stop. They go on to say, what must it be essential or necessary for? To achieving maximum medical improvement. And maximum medical improvement is a restriction because it eliminates an entire category or class of treatments that the legislature did not allow, and that the unambiguous regulation does not allow. It allows only 4 reasons. They've added a 5th. It's straightforward interpretation with respect to that. So when we look at the first question, is it unlawful? It is unlawful if it's an additional reason, which it is. Their own policy, their own coverage letter states that it's an additional reason, not just a definition. And when an average person reads their policy and sees that it's incurred for necessary medical expenses, and they must also be essential to achieving maximum medical improvement, they would understand that to mean it must be both things. And for that reason, it's very clear that it's an additional reason over and above what is a definition. And they tried to get around it by being clever and using the word component. But the fact is that it's both. It must be both under their policy. And for that reason alone, it violates the WAC. But as Justice McLeod pointed out, it is more limited to say that it is for curative only, because once you reach a cure, many people who are injured in car crashes have continuing pain that should in no way eliminate their ability to obtain treatment. They should have the same right as everybody else to continue to seek treatment, to continue to do the activities of daily living, to continue to be employed gainfully. Nothing in any of the legislative history or the clear interpretation of this statute would suggest that those people should be excluded, as State Farm's policy admits. And they suggest, in answer to Justice Wiggins, that as a part of that, they should be allowed to just exercise their discretion under the policy. Well, that's not how insurance policies work. We don't leave it to insurance companies to decide what they're going to cover and what they're not going to cover when we're dealing with a mandated level of insurance in a particular case, as we are in this case. PIP is mandated by the legislature. Inherent in that is a public policy that everyone should have it. Thank you.
Court will be in recess for 10 minutes. Thank you, counsel.